Judiciary is acting as a super parliament, and Article 142 of our constitution is being used as a nuclear missile against the democratic forces in our country.
Article 142 has become a nuclear missile against democratic forces?
These are the words of Vice President of India, Shri Jagdeep Dhankar, against the recent pronouncement of a judgment by Honorable Supreme Court of India, where they said they fixed a timeline for the governors in our country and the President to give assent to the bills passed by the legislative assemblies in our country. Now, this statement has sparked numerous debates around judicial activism, judicial restraint, and judicial overreach in our country. And because of this, judiciary is at the forefront and judiciary of the country is being scrutinized. Now, what is this Article 142? What is this complete justice debate? What is judicial overreach and what is judicial restraint? And is judiciary really taking over the powers of the parliament? Is judiciary really making up the laws? Or judiciary is doing its function properly? All these issues we'll be trying to answer in this particular session. Hello, my name is Preetpal Singh and you are watching Perspective. Now, Honorable Vice President of India, during a recent address, said that we have judges who will legislate, we have judges who will perform executive functions, who will act as a super parliament and absolutely have no accountability because law of land does not apply to them. These are the words of our Honorable Vice President against the judiciary. He also reignited concerns over lack of transparency and lack of accountability against the judiciary in our country. See, if laws are to be made by the judiciary, if executive decisions are to be taken by judiciary, then the point of having a separate executive, point of having a separate legislature is nothing. Then judiciary should be doing each and everything in the country, and executive should be following the orders of the judiciary, and the legislature should also be following the orders of the judiciary itself. This is what the views of our Honorable Vice President of our country manifests into. But on the other hand, if you see the landmark decisions in our country, whether it be Keshwananda Bharti's case, whether it be Bhopal gas tragedy, eventual judgment of the Supreme Court, whether it be Vishaka guidelines given by the Honorable Supreme Court, whether it be the coal allocation scam, whether it be restriction on the sale of alcohol, whether it be Ayodhya's land dispute, whether it be Rajiv Gandhiji's assassination case, or whether it be Chandigarh's mayor poll and how the outcome of the poll transpired, in all these landmark judgments and historic decisions taken by the Honorable Supreme Court of India, Article 142 of our Constitution has been invoked, which means the principle of complete justice has been taken forward by the Honorable Supreme Court of our country in pronouncing these judgments and making these decisions, which makes us understand that Article 142 has been helping Supreme Court of India to come up with judgments which help the public at large, which serves the public at large, and which gives a sense of being complete justice done for the welfare of the society at a large level. Now let us understand the simple basic thing. What is Article 142 of our Constitution? Now, Article 142 of our Constitution, it grants Honorable Supreme Court of our country the power to deliver complete justice. And it has been used by Honorable Supreme Court in several landmark judgments like Babri Masjid issue, Vishaka guidelines, which I earlier told you, and mob lynching guidelines, or also during irretrievable marriage breakdowns as well. Now, critics to this provision argue that it provides excessive discretion to Honorable Supreme Court of our country, while defenders say that it is a necessary instrument for justice in exceptional circumstances. And many people defending this particular article say that it helps in upholding the spirit of our constitution in the country, which is why this article is very essential and necessary for judicial sovereignty and functioning of the country in a better way. Now, the earliest reference to Article 142 can be seen in the year 1958, when in Bihar Assembly, there was an issue about some remarks being expunged. Now, in relation to that, Article 142 was seen being used for the first time in independent India. And for several decades, Article 142 of our Constitution was invoked very sparingly by the Supreme Court. But 1990s onwards, it has been used quite frequently, and the frequency of use has considerably gone up. And since the year 2002, there have been at least 20 instances of this particular article being used by Supreme Court every single year. So every single year, on an average 20 times, this article has been used by the Supreme Court. Now, according to a study done by IIM Ahmedabad 2024, it suggested that from the year 1950 to the year 2023, this Article 142 complete justice criteria has been used by Supreme Court. So in 1579 cases, Supreme Court of India has used this Article 142 or this complete justice provision. However, in only 50% of these cases, the court has explicitly used its power. So they've mentioned about Article 142 in 1579 cases, but only in 50% of them the court has actually used its power under Article 142 to give a judgment. And in 11% of the such cases, the court has declined using the power under Article 142. And 39% of the other cases, the court has been ambiguous or not used this particular power. Also, the report added that in 2018 and 2019, this Article 142 was invoked more than 86 times, which is the highest till the year 2023. And the landmark cases where Supreme Court have used this article, we have already covered. But this whole issue is not just about Article 142 being used. There is a very big underlying issue to it as well. And that issue is that to what extent the judiciary is powerful as compared to legislature or executive. Because we all know that 10 years back, National Judicial Appointments Commission, which was formed as a law by the parliament of our country, was struck down by the Supreme Court, saying that it challenges the basic structure of the constitution. Now, because of that, the tussle between Supreme Court and the central government, it grew over the years. But still, central government has over the years respected the judgments of the Supreme Court, whereas Supreme Court as well, time and again, have sided with the central government multiple times, but have also announced judgments against the central government as well multiple times. So which is why the balance between the central government, that is the executive, and the judiciary has been maintained since the last 1 decade. But time and again, many people from the executive or the legislature, they have come up to ask for a judicial accountability. But the case which happened in the last 1 month, where one High Court judge in Delhi High Court judge, money was found, half-burnt money was found in his residence, which came up with the case of corruption against that particular judge. So while we say that the judiciary and executive and legislature, they are balancing each other, what about the accountability and responsibility of the judiciary? Because see, in judiciary, what very classic thing is done is that judges themselves, through the collegium system which I have discussed in one of the earlier lectures, judges itself, they elect other judges, or they select other judges to be specific. So judges are the one who are selecting other judges. But in executive, that is not the case. Executive is selected by the parliament of the country, and the parliament is elected, the Lok Sabha, the lower house of the parliament, it is elected every 5 years by the public of the country. So here there is a direct responsibility and direct accountability of our legislature, parliament, and the Lok Sabha to be specific, to the public. Direct accountability is established. But in judiciary, it is not the case. And executive as well is responsible to the legislature, which is why if executive doesn't enjoy the support of the legislature, executive can't function, and there would be a no confidence motion against the executive, against the government. But that is not the case against the judiciary. Judiciary, the only way a judge can be removed is through impeachment. Until today, in independent India, not even a single judge has been impeached. Which is why judicial accountability and judicial responsibility is the issue which is at the core. And you can add n number of words over here. We call it as judicial activism. Sometimes when judiciary, they overreach, they use powers which they should not, then we call it as judicial overreach. And sometimes when judiciary consciously stays back and says that it is the work of the executive and legislature, then we call it as judicial restraint. But the underlying issue still remains. That is judiciary in our country accountable enough to the people or not? Now for that we have to understand judiciary's role. See, Indian judiciary is constitutionally placed as the guardian to our constitution and the guardian to the rights of our citizen. Now it exercises wide powers, either through judicial review, which is not explicitly mentioned in the constitution but it is inferred, or through Article 142 to uphold justice and to ensure accountability, including for the executive. But there are several issues in its functioning as well. And one of the biggest issue is the lack of transparency in judicial inquiries. So multiple times you have seen internal inquiries in the judiciary itself not being transparent enough. And public doesn't get to know what is the nature of the inquiry done, who did that inquiry, and what were the proceedings of that inquiry, and eventually what came in that inquiry. What the public gets to know just at the end is that was the inquiry making the person guilty or not guilty. That's all. So basically there is lack of transparency, lack of accountability in case of any internal inquiry. And then the last 1 month case which we saw, money found in a Delhi High Court judge house, in that case also there is lack of transparency. So that is one very big issue. Second big issue is judicial direction to constitutional authorities. Now judiciary giving directives to the governors of the states, to the President of India, that has also not gone well with the central government. And this is again one place where they have criticized the judiciary. And the third big issue is of accountability deficit, where our Honorable Vice President of India also says that judiciary is not directly accountable to the public. It is accountable to the legislature, but legislature as well to make a Supreme Court judge or a High Court judge, to impeach them. It is a very tedious task, and usually, practically, it is impossible in Parliament, which is why judicial accountability is questioned, and it is not actually there. And when the central government tried to make judiciary accountable through National Judicial Appointments Commission, that Honorable Supreme Court of India strike down, calling it as unconstitutional. Now, one more issue which our Honorable Vice President of India highlighted was the size of the constitutional bench. Now, while the Article 145, Section 3 was framed, it mandated a minimum 5 judges to adjudicate constitutional questions, noting that at that time, the Supreme Court's strength was just 8 judges. But the current strength, it is 34 judges, which means for constitutional questions, for constitutional cases, the number of judges in the constitutional bench should definitely increase. So we need to reevaluate the number of judges who should be there in a constitutional bench. Also, one more big issue is when judiciary oversteps. Usually we call it as a threat to the doctrine of separation of power, where power is clear-cut separated between executive, legislature and judiciary. When judiciary intervenes into legislature, intervenes into executive, it threatens the overall doctrine of separation of power. Also, multiple times in executive decisions, it is said that to take executive decisions, the level of expertise in cases of environment, in cases of ethics, in cases of economy, in cases of finance, or in case of healthcare or education, wherever there is specific knowledge required, specialized knowledge, technical knowledge is required. Judiciary is not usually equipped with that technical knowledge. Judiciary is usually equipped with legal acumen, which is why for judiciary to take decisions on these executive matters is usually labeled as judiciary stepping into the work of executive. And this so-called judicial overreach can be termed as harmful for the country from different quarters. And multiple times experts say judicial overreach can be seen as a disregard by the judiciary for the elected representatives of the public. Because eventually the public has elected its representatives in the form of Lok Sabha and then the Rajya Sabha, which is indirectly elected. People have elected their representatives in the parliament who then form the government in the country, and then they perform executive functions. People have elected these people who will make laws, who will execute laws, and will be executive. But people have not elected judiciary. And this is an ironical situation that judges themselves, they select other judges through the collegium system, which is again not very transparent and usually termed by several experts as opaque. Now, to understand this issue in a broad light, what we need to understand is the genesis of our polity. See, Indian constitution and Indian polity, this system blends the British-style parliamentary supremacy and parliamentary sovereignty, the British-style sovereignty of the parliament, and also American-style judicial supremacy as well. So both the things are blended in Indian constitution and Indian polity, which is why Indian polity can be seen as a mix of both. However, as always, there are two sides to the coin, which is why there is other side of the story as well, which says that judicial sovereignty should be paramount. And if judicial sovereignty in any of the democracy is compromised, the democracy doesn't remain democracy at all. For a democracy to be functioning in a healthy way, and for a democracy to be functioning in the most effective way, effective judiciary, transparent judiciary, as well as sovereign judiciary is required. So judiciary needs to be independent. Judiciary needs to be independent of any of the stresses of executive or legislature. Only then judiciary would be able to uphold the law of the land and would be able to give justice to the population, to the public. But that shouldn't come at the cost of not being transparent. Judiciary needs to be transparent. It needs to be accountable to the people in some way or the other. And yet, it needs to be independent, because independent judiciary is the one who ensures that executives, they don't overreach and they don't overdo, and executive, they function well, and the legislature, they function well under the law of the land, and they don't breach the basic structure of the constitution, and they don't breach the constitutional provisions as well. For that, independence of judiciary is paramount, and it is not questionable at all. But still, should judiciary not be transparent? The answer is no. It should be transparent. And while we see this issue as being in two extremes, that one side says judiciary is overreaching, judicial overreach, and other side we say that independence of judiciary is being questioned, we should not see this issue in the two extremes. See this issue in light of executive, legislature and judiciary functioning harmoniously for the welfare and development of the nation. If there is harmony, cooperation between judiciary, executive and legislature, only then a country could prosper. And definitely there needs to be a system of checks and balances in our democracy, because our constitution provides for separation of power. Our constitution also provides for checks and balances, which is why checks and balances through judicial independence is paramount. Judiciary keeps a check on the legislature, on the executive. Legislature also keeps a check on the executive and the judiciary, and it's the other way around as well. And definitely all is not wrong with the judiciary. Judiciary over the years have a very well played an integral role in upholding justice in the country and giving so many landmark judgments, which makes the public's faith in judiciary, public's trust in judiciary even more strong. But still, we should not keep a blind eye to the faults in judiciary as well. The issue of pendency of thousands of cases in judiciary, especially lower courts, the cases of judges' position being vacant, and the biggest issue of lack of transparency and accountability in some areas, some grey areas present in judiciary. These issues needs to be talked about, needs to be debated at, and a policy analysis needs to be done at an urgent basis, so that a new law ensuring judicial accountability and judicial independence at the same time should be there, in order to ensure that all these three pillars of our democracy should function in the best possible way for the welfare of our country, that is India. And if we ensure this, the whole debate in itself will be solved, and we would be living in a country where all the three pillars work in the most efficient, effective and the best possible way for the welfare of its public, for the welfare of its people. I hope you gained a new perspective from this session. What are your views regarding Article 142, its usage, and the comments made by our Vice President Shri Jagdeep Dhankar against the judiciary? Please let me know in the comment section. And what are the reforms you would propose in the judiciary? Please let me know that as well. I'll be very happy to read your comments. All the very best and have a nice day. Thank you.